Special investigative measures, such as secret surveillance, communications interception, or the use of undercover agents, are used across European countries to fight serious crime, terrorism, avert dangers to state security, or tackle corruption. Supported by rapidly evolving technologies, these surveillance practices are performed in secrecy, without the knowledge of the target. And when improperly used, they endanger fundamental human rights, including the right to privacy, the right to a fair trial, the freedom of information and expression, and freedom of religion. These rights are cornerstones of democracy. Their infringement undermines the rule of law and the citizens' trust in the state. For these reasons, democratic countries require their police and intelligence services to obtain judicial warrants before using special investigative measures. It falls under the duty of the courts to scrutinize the use of intrusive measures by security services and to strike a fair balance between two competing state responsibilities, to ensure public security and to protect individual rights and liberties.
Posebne istražne radnje, osim efikasnosti u borbi protiv organiziranog kriminala, terorizma i drugih najtežih oblika kriminala, sa sobom uvijek nose jednu opasnost, to je zadiranje u osnovna ljudska prava, prije svega prava na privatnosti i prava na pravično suđenje. To nije specifičnost Bosne i Hercegovine, to je problem o kojem se raspravlja u cijelom svijetu, a nažalost mi smo navikli da svi globalni problemi u Bosni i Hercegovini nekad dobiju na posebnoj težini u okviru naših granica.
In Bosnia Herzegovina's complex judicial system, there are 4 criminal procedure codes and 67 courts mandated to authorize special investigative measures, which can be implemented by 16 law enforcement agencies at different levels of governance and 1 intelligence service. In 2017, the Bosnia-Herzegovina's Constitutional Court declared unconstitutional a number of legal provisions regulating judicial authorization of special investigative measures. The Parliament's delay in amending relevant legislation has left in the sole hands of the judiciary the responsibility to correct law deficiencies through a judicial practice that observes the highest human rights standards, as they are entailed by European Court of Human Rights case law. Following long-term consultations with judicial institutions from Bosnia-Herzegovina, in September 2018, DCAF, Geneva Centre for Security Sector Governance, and its partners have launched a project aimed to enhance judicial capacity for independent supervision of the use of special investigative measures.
Our project has created opportunities for a large number of practitioners to acknowledge the differences that exist in regulation, in procedure, in practice across different jurisdictions in Bosnia and Herzegovina, and it allowed them to identify and to analyze the good practice already developed by some of the courts and prosecutorial offices in the country. Very quickly, it emerged as a priority for the project the idea to develop a practical guide that would synthesize both local good practice and the most recent standards of the European Court of Human Rights. So the project has set up a working group made of 20 judges and prosecutors from all the jurisdictions in Bosnia and Herzegovina who started developing this practical guide based on their knowledge, their experience, their research efforts and time.
Ono što odvaja ovaj priručnik od ostalih su 2 dimenzije. U njegovom radu nisu korišteni neki vanjski eksperti, da je ovo proizvod domaćih stručnjaka. Sa druge strane da je to jedan visoko praktična publikacija, sa primjerima iz prakse.
Autorsko djelo zapravo sudija i tužilaca koji se u svom svakodnevnom radu upravo susreću sa predlaganjem posebnih istražnih radnji, njihovim provođenjem, izvođenjem dokaza koji su rezultat istih tih radnji i konačno njihovom ocjenom.
Koristit će ga ne samo u krivičnom pravosuđu, koristit će ga i druge ustanove koje se bave edukacijom. Ja bih ipak koristila ovu priliku i naglasila da smo i na Pravnom fakultetu Univerziteta u Sarajevu u okviru izbornog predmeta koji se odnosi na kliničko obrazovanje studenata prava uvrstili sadržaj ovog priručnika i studenti će ovu tematiku proučavati cijeli ljetni semestar.
The Benchbook is used as a standard resource in judicial training in Bosnia and Herzegovina, helping the dissemination of good practice across judicial institutions. The process is similar with the incorporation of the Benchbook on communications interception in judicial training in North Macedonia. The interest shown by judges and prosecutors in both these countries for training and continuous professional development on topics related with special investigative measures confirms a regional trend towards the affirmation of judicial courage and vigilance in the examination of the use of intrusive methods by state authorities.
As one judge in our working group has put it, the Benchbook is a pathway, a comprehensive pathway on how to issue an order. And making such practical guidelines available to young judges and prosecutors will definitely support the harmonization of judicial practice across the region and will contribute to more successful criminal investigations, ultimately consolidating a space of security and stability in the Western Balkans.